The other thing that always gets my blood boiling, and Gene probably, I've read enough Gene blogs on this, is when a district court or a federal circuit says, I see this claim term, but it's nowhere in the specification. And why are you bothering us? And we now I have to have two experts. One's fighting on this side. One, I mean, Gene has written probably, I don't know, Gene, 100 times, maybe
Yeah.
more. Okay. I always say that that's how an associate can get fired on me. That's but the reason I say that is that's what's great about this is so you can literally the definition, you can go through your claim, and each term in your claim you can say define, and each paragraph, so you'll have a paragraph on each or more on each term. So you're not going to have judges throwing up their hands and saying, you're asking me to define a term and it's nowhere in your spec. And again, I get it, because most of us only have limited amount of time, limited budget, so we could only do something. My running joke is, as a patent prosecutor, you get X dollars. As a litigator, you get X multiplied time 100 or 1,000.
Yeah,
And
like
so,
X to the X power.
yes, and we get blamed all the time. It's like, wait a minute, if I had your money, my thing
Yeah.
would have been. So this is why this levels the playing field. It allows us to do this, because no more are you to have a judge. Or look, if we do FDOs, many times we'll look at a claim term when we're doing an FDO for a client and looking at a patent. We're going to say, well, this term appears and it doesn't appear in the spec. So I think it could mean this, but I think it could mean that. And the client looks at you with four eyes and says, well, you're the attorney. Tell me about it. And so, it's just about being able to, again, make a better work product. And I think this example was an excellent example.
Yeah,
Gene,
and just to
anything?
pick
Yeah.
up on that and riff on that a little bit, Barry, like one of the things that's been frustrating about this whole 101 area for years now is most of us, I think, have the understanding that the courts are throwing away innovation. It was innovation drafted for a variety of different reasons. Some of them was budget. A lot of it was simply the law was different and you were defining an invention for a different target. It's not that there's no innovation there. So what these tools then do, I mean, because just the cynical view, or maybe it's a realistic view, whatever you get to the federal circuit, they're going to say, or they're going to want to default to say that you did not do enough. And they're going to point to what you didn't do. So having tools like this that help you do more than you can do now, and this clearly is going to let you do more than what you do now, is only going to pay dividends later on, create stronger assets, better patents. And, frankly, the federal circuit at some point will probably be out of a job if all of us start using this, because these things will be defined. There will be plenty of disclosure in your spec for your claims.
Amen, brother. So again, war stories, and Gene could say the same thing. Many times you'll pick up a prosecution from a client who has a previous firm, and they're on the fourth RCE, and you look at this and like, it's not the examiner's fault. The fault was that the person who is drafting the claims doesn't have the right claim. And again, this tool will help you do this. So, I always say the patent office wants to do the right thing, but you've got to give them a set of claims that make sense. So this, I also believe, will help in compact prosecution, which will just help you get a patent quicker, and it'll help the patent office understand your invention. So, many times we get a new matter rejection because we've changed something and the claim, and it's a problem. And this would help you make a more robust application. So I don't know how many times I have to say this, but you can tell I'm sort of a little biased that I think this will really help my work product.